I wasn't in court for Justice Craig, but I was told that he was granted bail by the judge after his bail application was moved by Professor Sam Amadi. And the conditions that I was told include that he must provide two level 15, one level 15 officer that must provide the tenancy agreement that have run concurrently for 4 years, and also that he must deposit his international passport, and that they are going to commence the trial. But they've commenced the trial, even though the DSS did not serve his lawyers the evidence required to even commence the trial, which is an anomaly. You can't commence the trial without the other party knowing
having the process.
The processes. They should have served any processes, but I would imagine they don't even have any processes anyways. And why would anybody ask to be deposited to deposit their passport over cybercrime, so-called cybercrime offenses? Utter lawlessness.
And today you are supposed to appear before Justice Umar.
Yes, we have a civil case in front of Justice Umar, and our lawyer, who is nowhere here, has asked him to return the file, right?
Yes. The X matter.
Yes.
Yes.
Between us and Twitter. And,
yes. The application we made before the court today is based on the fact that we had two matters before the court in respect of the post. The publication, there is a subject matter of those two civil suits. The same publication is also the subject matter of the criminal charge. When we filed the civil suit against Twitter and Facebook, that is X and Meta, our point then was that if SSS is saying that the publication of Mr. Sowore violates Nigerian criminal law, the cited cybercrime, the cited criminal code, we are saying without bringing him before the court for a judicial determination, there is no way you can brand that publication illegal. That was the point in those suits. You cannot unilaterally. This is different from a user of the platform flagging a post. No, it's different. It's a government writing to that platform to say that this person committed a crime under cybercrime law and criminal code. That was the letter from the DSS, from the DSS to Meta and Next. And that was the foundation of those civil suits. The court determined the case against Meta and DSS. And the court said, no, they have the right to do this. The court said that there is no breach of right of fair hearing, there is no breach of right of freedom of association, there is no breach of right of freedom of expression, that they can do this. And there is still a pending matter, a sister matter on the same publication, against the same persons, on the same issues, on the same constitutional provision, against X. And our application is to defend that. Look, having determined that matter, having made those evaluative findings and pronouncements, the court cannot look at this case with neutral. We're asking the court to disqualify and send the file
to the CJ. Yes.
That was what happened today. And in vindication to our position, there is a criminal charge pending. And that's what we said then. Before you can say this post is illegal,
yes,
under all of these laws you are citing, why don't you go before the court? The letter came before the court to file a charge, and that charge has not been determined to show that that branding of it as illegal ordinarily has been overtaken by events. We want the court to look at it neutrally from the angle of the fact that what you have said is that this post is illegal under the cybercrime law, under the criminal code, and we are saying you can't do that unilaterally, you must come to court. We filed a case. Later you came to court to ask the court to make it illegal. The charge has not been determined.
Yes.
So what are we now saying? And because the court has determined the case against Meta to say that, look, you cannot talk about all of these things, you cannot ask the court to say they have breached your right to fair hearing, to freedom of expression, to freedom of organization. Court has determined all of those things. We are saying the court cannot look at the case against X with a neutral. We want a fresh eye.
They have already taken a position.
So that is the application. We are not indicting the court, we are not saying the court, no.
We have always condemned that the actions of security agencies who take over the premises of our courts. You see, the fundamental breach of access to justice starts from the gates of the courts.
Yes.
If you cannot enter the courtroom, there's no way you can get fair hearing within the courts. There's no way you can have access to justice. And this is the time to call on the NBA to take a definite position on the incessant, reckless, irresponsible, and unlawful takeover of the duties of court securities that prevents lawyers, litigants, and even sometimes judges, witnesses from accessing the court for their cases. Today, we experience the worst form of abuse when a lawyer was punched in the face by court security who was instructed by the DSS to do it. And this was captured on tape. A lawyer was punched in the face by court security. The man is still there. So there is no way everybody that has a case in this courtroom comes to block the gate of the court. If it's the EFCC, they block the entrance of the court. If it's the police, they block the entrance of the court. If it's the DSS is the most reckless in this manner. They take over the premises of the court at will. Not only do they take, even if they are using just one courtroom, they will block the entire court and they will block the entrance of the court where they have a case. There's no way anybody can get justice in a court where the DSS has already taken over the premises of the court. I don't know why lawyers participate in this charade. And that is why the Nigerian Bar Association, who interestingly has been a little active these days, should make a position known on this matter. They should not wait until election season before they become activists. They should take a position that except these hooligans stop taking over court premises, they will not participate in litigation. It's as simple as that. Supreme Court justices in Pakistan at the time protested against the government when they were violating the sanctity of their courtrooms, and they had to stop. So why is it that you allow this to happen here? And you justify it by saying that, oh, it is because we suspect that some people are coming to court to cause mayhem. You are the ones causing mayhem within the premises of the court. You are the ones abducting people, beating up lawyers. Even today, when El-Rufai was leaving court after he was granted bail, they still tried to prevent us from even saying hello to him, how is prison? You know, we had a whole altercation around that. This must stop, and it must stop now, definitely. And we have lawyers. One of the lawyer that was punched is actually a lawyer of mine. You know, I don't think he's here. We must have gone to treat his injury. Yes, it's not seen his injury. Unthinkable what happened today. It's sad, yes.
I think it's very, very important.
Yes.
Yes, in 2021, similar thing happened, you know, at the gate of this court. In fact, that day, Mr. Sowore was also arrested when they are in the academy, you know. Yes. The entire premises was condoned off. My junior lawyer was manhandled, you know. I was also to an extent, you know, they tried to prevent me from entering the court. I filed an action, you know, in this court against the Chief Judge of the Federal High Court and the communication officer. That day, it was a publication by a communication officer, you know, listing the number of media houses that will be allowed, preventing all others whose names are not on that list. And it was on the basis of that they found Mr. Sowore that he will not enter because his name was not on that list. And the suit was to question the rationality behind a communication officer of a court giving a list to the security men or DSS to say that once the name of the media house is not on this list, don't allow them to enter. And that matter was in court. You know, it was a very big considered matter, and I think it was going to resolve many things. We were coming to court. It was before my Lord Justice Seku. We were coming to court. You know, all of a sudden there was a day the court didn't sit. At the time the matter was adjourned to, we were not communicated. When I came back, they just said they have dismissed the matter. It was not even struck out. They said it was dismissed. All the parties have filed their processes. We have also responded. Why will it be dismissed in case the court didn't sit and we are coming to court to find out the date? They said it was dismissed. Yes, I said no. We filed an appeal against that. But I'm using this opportunity to call on them because of the importance of that matter. The Chief Judge of the Federal Court made a court practice direction, and I am very sure it's related to that suit, to now determine, you know, the radius of which are people coming to court for litigation can stand and all that. And I still filed another case against my Lord the Chief Judge of the Federal Court and the registrar. That matter is still pending before my Lord Justice Seku before the suspension. You know, all of these matters are not supposed to be personal matters. They are matters that Nigerian Association ought to take up. Federal headquarters, Abuja being the headquarters, national headquarters. You come to the gate and you will see people wrestling. The security men and DSS will be wrestling with lawyers, you know, who are corporately dressed coming for their business of the day. And the NBA cannot say they are not seeing this. The NBA cannot look away. And I want to also commend the leadership of the NBA, you know, for these few days. Some of the matters that they have responded to in respect of matters that violate. This is one of them.
Yes.
And it's a continued violation. It happened today. Today is 18th of May 2026. We are calling on the NBA to take a proactive response to this. If that is only legacy that this leadership will leave for us, fine. Let it be there. If it is happening here, how much more? How much more in the states, the countrysides, where we don't even think the press are present? That means they can beat the lawyer up without anything happening at the gate of a court.
No, the lawyers are being asked to cut grasses in some.
It is. We are calling on the NBA. The NBA must react. The NBA must make a position.
Yes.
Thank you.
Thank you. The 3 years of the Tinubu administration is the 3 years that the locust has eaten from the life of Nigerians. And we cannot take the judiciary alone. It has to be all sectors. The petroleum sector, the financial sector, the judicial sector, the legislative sector, the educational sector, hunger and poverty sector, starvation sector. Tinubu came to fail, and he has failed woefully. If there's any other adjective that can be used to describe how much of a failure he is, that's why I said this is 3 years that the locust has eaten from your life. If you were born 3 years ago, just start counting on when you are born after Tinubu leaves. That is all I can tell you. It's not only in we're just here discussing what has happened under the military. The military don't stand in front of courts to beat up lawyers. They don't. And court judgments are implemented even under the military. But under the Tinubu regime, they have hijacked the Supreme Court, the Court of Appeal, and the Federal High Court. These courts are populated by their family members.
Building houses for the judges.
They are building houses for judges.
Giving the staffs.
Giving staffs land allocation. They are giving them grants and bribes to make sure they circumvent the course of justice. It is terrible. I have been in the middle of it all, facing five criminal cases in the last 2 years alone over cybercrime. Anytime I speak, they will take me to court to file a criminal case against me. So nobody is in a better position to tell you that the judiciary is gone than myself. Yes. Man, these 3 years of Tinubu never happen again. Revolution. Oh, yeah. We are not hiding. Tinubu is a one-term president. We came for 2 cases. The most important one was Justice Crack. He's been granted bail, although the bail conditions were ridiculous. But the lawyer said they'll work on it. What we had demanded for was the Ministry of Justice to discontinue the case. There was no offense committed, so there was no basis for prosecution. My own case was against Twitter. And we have asked the judge to return the file to the CJ because he has already ruled on a sister case in a way that we believe will affect his judgment in the next case. Yes. They said he's a level 15 civil servant. He has to drop his international passport, and also that the level 15 civil servant must provide rent agreement for 4 consecutive years. They don't even want the level 15 civil servant to progress. It has to be someone who is renting house from, you know, these are ridiculous conditions placed in his way. My worry is that even after meeting the conditions, the lawless DSS might decide not to release him, claiming that they want to re-verify, because they did it to me before in 2019. After meeting my bail condition, they said I should go and bring my sureties to the DSS. So I gave them a middle finger, and that cost me another 1 month in detention. And when they finally released me, the next day they came and abducted me here at the Federal High Court. So I just hope the lawyers understand who they are dealing with. But if they don't release him within a reasonable period, we will take action. We are always ready to take action. Even, you know, today the lawyers wrote a press release that we should not come to court. We don't owe the lawyers any obligation to fight for justice. We owe Justice Crack and his family, but most importantly, posterity, to fight to ensure that his rights are not violated. That's what we came here to do today. And you all reasonably did fantastically well. And I'm sure it is because we're outside that he got his bail approved today. I was not in court because the DSS did not allow me to attend the trial. So, but I think we have all gone past that. The bail has been granted. His lawyers have acted on his behalf, and we should move on with our lives.
Sir, as regards your case with Twitter, should the judge refuse to hand your file over to the CGN, what's next?
You can take it home. That's fine. Yes. He has to, but if he refuses, then we'll take it from there. Because we also have another recuser coming from in the criminal matter tomorrow. So we are going to fight for him to recuse himself, because he was the judge that asked my lawyer to kneel down. And we've told him that that's the worst form of judicial rascality, to ask a lawyer that spent 6 years in law school and faculty of law to come and kneel down before a judge. I've never heard it before. A judge is also a lawyer. That's a disrespect to a fellow learned, a disrespect to a learned colleague of his. Unacceptable. So that one is also going to be filed hopefully tomorrow. Although he said he has an assignment and he might end up, but he said we should come at 3 o'clock tomorrow. Yeah.
Thank you very much.
Thank you very much.